Landmark cases of the U.S. Supreme Court.
The Brown v. Board of Education overruled the Supreme Court decision for Plessy v. Ferguson in 1896 that let state laws requiring segregation in public facilities under the doctrine of separate but equal. Let's look at the case.
No. Why not? This is an all-white school.
So?
Nope.
Where am I supposed to go to school then?
Down there.
But it's dangerous.
I don't care. On the case of Brown versus Board of Education, we, the Supreme Court, conclude that if the tangible factors of segregated schools are equal to separate black children from other similar age and qualifications solely on the basis of race, generates a feeling of inferiority with respect to their status in the community, and it may affect their hearts and minds in a way unlikely to ever be undone.
Thurgood Marshall and the NAACP Legal Defense and Education Fund handled this case. The case was brought in front of a 3-judge panel at the U.S. District Court and ruled in favor of the school boards. The NAACP appealed to the U.S. Supreme Court. Marshall's oral argument raised a variety of legal issues. The most common one was that separate school systems for blacks and whites were inherently unequal and violates the Equal Protection Clause of the 14th Amendment. He also argued that segregated school systems had a tendency to make black children feel inferior to white children, and so the system should not be legally permissible.
Engel v. Vitale ruled it unconstitutional for state officials to conduct official school prayers. This case arose when a group of parents sued on behalf of their children. They argued that the New York state law to start the day with a non-denominational prayer violated the Establishment Clause of the First Amendment and the Due Process Clause of the 14th Amendment. Let's take a look at the case.
Almighty God, we acknowledge our dependence on Thee. We beg Thy blessings upon us.
Stop! I won't let my child participate in this prayer. I'm taking this to the Supreme Court.
Order in the court. The Supreme Court has its ruling. Official prayer in public schools is a violation of the Constitution, which states, Congress shall make no law respecting the establishment of religion. The plaintiffs argued that opening the school day with such a prayer violates the Establishment Clause of the First Amendment to the United States Constitution. The governments of 22 states signed on to an amicus curiae brief urging affirmation of the New York Court of Appeals decision that upheld the constitutionality of the prayer.
In Tinker v. Des Moines, which ruled that free rights should be protected and that students don't shed their constitutional rights at the schoolhouse gates, happened when John Tinker, his sister Mary Beth, and a friend were sent home from school for wearing black armbands to protest the Vietnam War. Their school had established a policy permitting students to wear several political symbols, but had excluded the wearing of armbands protesting the Vietnam War. Their fathers sued, but the district court ruled that the school had not violated the Constitution. The Court of Appeals agreed with the lower court, and the Tinkers appealed to the Supreme Court. Let's look at the case.
Hey, that Vietnam War is pretty terrible, huh?
Oh yeah, I've been watching updates on the news.
I think we should protest tomorrow by wearing black armbands.
Let's do it.
You two, what are you wearing?
Armbands to protest the Vietnam War?
That's against school policy.
Yeah, but you're restricting my freedom of expression. I'm taking you to the Supreme Court.
Well, I'm giving you a detention.
What?
Order in the court. We have decided that students are entitled to exercise their constitutional rights even while in school. The justice reasoned that neither students nor teachers shed their constitutional rights to freedom or speech or expression at the schoolhouse gate.
In Tinker v. Des Moines, a judicial conference was held, and the Supreme Court, on a 7-2 vote, voted in favor of Tinker ruling that students retain their constitutional right of freedom of speech while in public school because student expression is protected by the First Amendment even while in school. School officials must provide constitutionally valid reasons for regulating student expression. School officials must show that the expression would cause a material and substantial disruption, where Tinker's protest with the armbands was silent and did not cause any disruption in the school. Roe v. Wade, which ruled it unconstitutional for women to be denied the right to an abortion, happened when Norma McCorvey, under the alias Jane Roe, was denied an abortion in Texas since her life wasn't in danger. The case reached the Supreme Court after being issued a writ of certiorari. Let's look at the case.
Hi, my name is Norma McCorvey, and I wanted to get an abortion.
Hello. Okay, so just a quick questionnaire. Is your life in danger?
No.
No. Well, I'm sorry, but you can't get an abortion.
Why not?
Under Texas law, if your life isn't in danger, you can't get an abortion.
But that invades my right to privacy.
I didn't come up with the law, ma'am. You're going to have to talk to him.
Harry, wait, I'm going to sue you in the Supreme Court.
The court, in the case of Roe versus Wade, the court has ruled that the right to abort falls under the right to privacy derived from the Fifth Amendment and the Due Process Clause of the 14th Amendment. States can pass laws regulating second and third trimester abortions only.
Decided simultaneously with a companion case, Doe v. Bolton, the court ruled 7-2 that a right to privacy under the Due Process Clause of the 14th Amendment extended to a woman's decision to have an abortion, but that this right must be balanced against the state's two legitimate interests in regulating abortions: protecting prenatal life and protecting women's health. Arguing that these state interests became stronger over the course of a pregnancy, the opinion of the court resolved this by tying state regulation of abortion to the third trimester of pregnancy.